Hi, good afternoon. I'm Daniel Lublin, and I have with me Simone Ostrowski, one of our associates at the firm. And we're really pleased to be with you today. We're doing our second installment of our Facebook Live series, and we've picked an isolated topic, but nonetheless one that's really important as it relates to severance packages and severance package negotiations for employees who have lost a job. So for anyone who is in a situation where they've received a severance package or they anticipate receiving one in the near future, this session today would be important for you. So what we're here to talk about today are what's commonly known as reemployment, or otherwise known as clawback clauses. And essentially what those are is it's a very common type of clause that one would find in a severance package, which essentially states that if an individual who's been dismissed and is on a severance package payment receives another job, the severance package would either cut off or there would be a deduction for income earned at that other job against that individual severance. So what we'd like to talk to you today about is really what are these clauses all about, how they should be negotiated, what do they say, what's fair, what's reasonable, what's not, and what you want to do if you find yourself in a situation where one of these clauses are in your contract. So first, maybe Simone, you can just have a little discussion of essentially the concept of mitigation in employment law, but specifically as it relates to a severance scenario. What does mitigation mean?
Well, all employees, when they lose their job, have a duty to mitigate their damages, or at least make an attempt to. So this is the idea that all employees, when they're terminated, should be making efforts to find other employment. And an employer basically gets a credit if the employee finds another job. So for example, the employer, if they're obliged or they agree to pay the employee, say 8 months of severance, if the employee reemploys 4 months into that severance period, the employer gets a credit for that reemployment.
Excellent, fantastic. So in any severance situation, I usually tell clients there are three key things that we look at. First is the length of the package. The second is the structure of the package, how it's paid. And that's what we're talking about today with respect to these reemployment or severance clauses. And the third is the quantification, how each month of damages is calculated. So we're really going to focus in on this second issue, which is essentially the structure of a clause. So Simone, when do these clawback or reemployment clauses arise, and which kind of severance packages do you see them?
I tend to see them in severance packages where the employee is getting some sort of salary continuation for a period of time after their termination. So in the example that I used, if the employer is offering to continue the employee's salary for 8 months after termination, you might see a salary clawback if the employee reemploys during that time. So the employer might say, listen, if you get a job during the 8-month salary continuation period, we're either going to stop your severance payments, or we're going to stop them and then pay you a portion of the remainder, or we might claw back some of the severance payments that you're already earning from your next employer.
Right. So I usually see as the most common form of severance package scenario is a salary continuation. There are such things as lump sum payments, and severance clauses or these reemployment clauses really wouldn't apply in a situation of a lump sum payment simply because the payment's being made up front. It doesn't matter if somebody finds another job. So the most common event, however, is in severance packages is typically a salary continuation arrangement with a type of clawback. And I would say I would see a clawback probably 75% of the time when an employee's received a salary continuation arrangement. So there are usually 2 or 3 main types of clawbacks. The first is the one you touched on, which says, if you find another job, we're going to cut you off and pay you half of what's left. Another one says, if you find another job, you have to notify us, and we're going to deduct dollar for dollar what you've earned at your other job against what we owe you. And the third is a full cutoff, an entire clawback from the moment you find another job, there's no further payments. How often do you see that last scenario?
I would say not very often, because it really doesn't give the employee any incentive to let the employer know if they found a new job. It just gives them an incentive to try to double collect both the severance and income from a new job. So what I tend to see the most is the scenario where if the employee reemploys, their salary or continuation payments cut off, but they get a 50% payout of the remaining payments.
Right. And just a general question, because this is what I'm asked, Simone, are clawback clauses fair? Are they legal?
They are legal, and I would say they're fair in the sense that employees could potentially get 50% of the remaining salary continuance payments under a severance package, as well as reemploying in a new job. So they're getting a decent payout from their former employer as well as reemploying, which, like I said earlier, they have an obligation to do.
I usually find if you actually work out the calculations, individuals who have a clawback that says you'll receive 50% of the payout in the event you find another job, if they find a job sooner than later, they'll actually do far better under that arrangement than they would actually do in court, because what a court would do is do the dollar for dollar deduction. In other words, if someone was owed $100,000 severance for a 12-month period, but then earned $50,000 doing reemployment or consulting work, a court would deduct that $50,000 entirely, whereas in the situation with the 50% payout, you would end up getting half of what's left. So I actually do find that they're not unfair, I would say that, and in many cases they can be better than what you would do in court, which leads to as a segue into my next point, which is what should be negotiated. So when you see a package with a clawback clause in it, what are you trying to negotiate if you're working on behalf of an individual?
Well, first I look at what's defined as other employment. For example, can the employee start their own business? Can they maintain a pre-existing part-time job? What's included within that definition? What's going to cut off the salary continuation payments? Are other perhaps benefits going to be cut off as well? Are the benefits only going to be cut off if the employee secures replacement benefits? All of these are terms that can be discussed and usually negotiated.
Yeah, so three main things. One is reduce the clawback itself. So either remove it or eliminate it or try to reduce the amount that's going to be cut off from your severance. The next is increase the payout you'll receive. So it's a clause that's 50%, see if we can get it to 75 or 85%. And the third is what I like to do a lot of work on is trying to redefine the meaning of other employment. Does it capture consulting agreements? What I like to say in a severance package is that this clawback clause doesn't apply unless someone secures comparable work, which I would usually define as approximately 75% of what they earned prior to termination. So those types of things. So Simone, broadly put, what's the point of all this? Why do we even care about these severance or clawback clauses, and what value is there to discussing them?
Because it results in more dollars in the employee's pocket at the end of the day. If we can negotiate a more employee-friendly clawback, we can take certain terms out, employees can end up with more severance.
Yeah, ultimately, this is one of the key things that an employment lawyer and our team can help people with when dealing with severance scenarios, is trying to find a way to have you end up with more money in your pocket, and dealing with these reemployment clauses is one of the key negotiating points that should occur in any severance package negotiation. So a good employment lawyer will be able to isolate and identify what are the issues as they relate to the clawbacks and how to negotiate to improve the package that you're receiving. And are there any questions that we have from the audience? No? Okay, well, it was a pleasure sitting with you today. Simone and I plan to do more of these sessions, and I hope that it's been informative for you. It's certainly an important topic for anyone who finds themselves in a severance scenario, so we're glad if you've tuned in, or if you're going to review this online afterwards. We appreciate your time, and if you have any questions, you're always feel free to get in touch with us. Our website, www.toronto-employmentlawyer.com, or you can call us at our main line is 416-640-2667, and we'd be happy to arrange a time to speak with you. Thanks so much for your time today.